If you are a green card holder, a lawful permanent resident of the United States, and you are planning to travel outside the country this year, or you have already been outside the United States for more than a few months, I need you to stop whatever you are doing right now and watch this video in full. Because in 2026, the rules for green card holders traveling internationally have fundamentally shifted in ways that most people, including many legal permanent residents, do not fully understand yet. And I am not talking about minor procedural changes. I am talking about policy shifts, expanded executive proclamations, new CBP scrutiny protocols, and USCIS internal review mechanisms that, if you are unaware of them, could put your permanent residency, something you worked years to obtain, at serious risk. This is not alarmist content. This is a fact-based analysis. And by the end of this video, you will know exactly what has changed, how it affects you, and what steps you need to take right now. My name is Raymond Crivello. I am a senior immigration analyst and consultant. And on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand, without the legal jargon, without the panic, and without the misinformation. Every update I cover is grounded in official policy, regulatory guidance, and verified legal sources. We do not do rumors here. We do not do speculation. We do analysis. And before we go any further, a very important disclaimer. I am not your attorney, and nothing in this video constitutes legal advice. This content is strictly for educational and informational purposes. Every immigration case is unique, and you should always consult with a licensed immigration attorney about your specific situation. That said, knowing what I'm about to share gives you a significant advantage when you do have that conversation. Let's get into it. Let me start with the big picture. Three major policy developments in late 2025 and early 2026 have dramatically changed the landscape for green card holders traveling internationally. And these three things are working together simultaneously, which is what makes the current environment uniquely dangerous for those who are not paying attention. The first development is Presidential Proclamation 10998, what is being informally referred to as the Expanded Travel Ban of 2026. Effective January 1, 2026, this proclamation expanded travel restrictions to cover 39 countries. Now here is the critical nuance, and this is what most videos get wrong. Lawful permanent residents, meaning green card holders, are technically listed as exempt from the visa suspension provisions. So on paper, your green card should still allow you to return to the United States. But here is where this becomes critical. Exempt does not mean unchallenged. What has happened in practice, based on documented cases and official CBP protocols, is that green card holders returning from any of these 39 listed countries are now being subjected to heightened vetting at ports of entry. CBP officers are asking detailed questions about intent, about ties to the United States, and about the purpose and duration of the foreign travel. They are looking at your pattern of travel. They are looking at whether you genuinely maintain your life in the United States. And if your answers are inconsistent, or if your documentation is incomplete, that secondary inspection can escalate into something far more serious, including expedited removal proceedings. The second major development, and this one is affecting far more green card holders than the travel ban, is a significant tightening of what CBP considers the threshold for abandonment of residence. Historically, most people understood the rule as follows: if you are outside the United States for less than 1 year, your green card remains valid for reentry. And if you are gone for more than 1 year, you need a reentry permit. That framework still exists on paper, but in 2026, the operational reality is very different. CBP officers are now treating 180 days, 6 months, as the informal presumption threshold for abandonment. If you have been outside the United States for more than 6 months, you may arrive at the border and face a line of questioning designed to determine whether you have actually abandoned your residency, and the burden is on you to prove that you have not. What are they looking at specifically? Your U.S. residential address? Is it active? Your U.S. bank account? Is it being used? Your most recent U.S. tax filing? Evidence of ongoing U.S. employment or business ties? Proof that your primary home is still the United States, not the foreign country you were visiting. If you cannot demonstrate these things, that conversation at the border becomes extremely complicated. Now let's talk about the third development, and this one came directly from inside USCIS. In January of 2026, USCIS issued an internal policy memorandum authorizing the re-review and in some cases re-interview of green cards that were issued after 2021. This is particularly focused on applicants from countries designated as high risk under the expanded travel restrictions framework. What does re-review mean in practice? It means that when you arrive at a U.S. port of entry after international travel, CBP officers, who have access to your immigration file, may flag your case for additional scrutiny based on this new guidance. They may review the original approval of your green card. They may look at the record of your entry interviews. They may cross-reference information that was submitted during your original application. Here is why this matters specifically for travel. If you are returning from a trip, even a short trip, and your case happens to be flagged under this re-review framework, you could face delays at the border while that review occurs. In more serious situations, you could be placed in deferred inspection, which means you are allowed to enter the country temporarily, but required to appear at a USCIS office for additional questioning. This is not common, but it is real, and it is new, and knowing it exists allows you to be prepared. This is what many green card holders are missing right now. They assume that because they received their green card through a legitimate, properly adjudicated process, they are fully insulated from further scrutiny. In 2026, that assumption is no longer entirely safe. Let me make this real for you with a realistic scenario, the kind of situation I want you to picture, because it is happening to people right now. Imagine a woman, let's call her Priya. Priya is a lawful permanent resident who received her green card in 2022 through her employer. She has been living in the United States for 4 years. She owns a car. She pays U.S. taxes. Her children go to school here. In November of 2025, her mother falls seriously ill abroad. Priya books a flight and travels home to take care of her. She stays for 7.5 months, 2 months longer than she planned because her mother's recovery was slow and her family needed her. She returns in the summer of 2026. She is confident she is fine because she was gone for less than 1 year. Her green card says it is valid. She has her documents. She approaches CBP. The officer looks at her travel history. 7.5 months abroad. They begin asking questions. Where is your current U.S. address? When did you last pay U.S. taxes? Do you have current U.S. employment? Priya has answers, but she did not bring the documentation with her. She did not know she needed to. No one told her. She is sent to secondary inspection. She spends 4 hours there. She is eventually allowed to enter, but she is issued a notice that her case may be subject to further review. That 4-hour experience, that secondary inspection notice, the anxiety of not knowing if her permanent residency is at risk, all of that was preventable with the right documentation, with the right preparation, with the right knowledge of what 2026 actually requires. Now let's talk about a tool that exists specifically for green card holders who know they will be outside the United States for an extended period. The Reentry Permit, which is filed on Form Y-131. A reentry permit is essentially official documentation from USCIS that allows you to remain outside the United States for up to 2 years without abandoning your permanent residency. It signals to CBP that your extended absence is planned, documented, and authorized. Here is the problem, and this is critical. In 2026, the average processing time for a reentry permit has ballooned to between 14 and 17 months. That is not 14 to 17 weeks. That is over a year of waiting. In some cases, approaching a year and a half, which means if you are planning international travel of more than 6 months starting any time this year, and you have not already filed your I-131, you may not receive your re-entry permit before you need to leave. And traveling without it, on an extended stay, creates exactly the vulnerability we have been discussing. This also means that the window for filing before your travel needs to be planned far in advance. You cannot decide in April that you are leaving in June for a year. By the time you file and receive your permit, you may have already been abroad for months, unprotected. The strategic lesson here is this. If you have any international travel planned for 2026 or 2027 that may exceed 6 months, even if it is uncertain, you should be speaking with your immigration attorney about filing Form I-131 now, today, before you leave U.S. soil, because once you are outside the country, you cannot file the re-entry permit. It must be filed and approved while you are still in the United States. So what do you actually do with all of this information? Let me give you a concrete 5-step action plan for 2026. Step 1. Audit your documentation before every international trip, no matter how short. This means having physical or digital copies of your green card, your most recent U.S. tax return, a utility bill or lease agreement showing your current U.S. address, and evidence of active U.S. bank accounts or employment. Do not assume CBP will simply take your word for it. Come prepared to demonstrate your ties to the United States. Step 2. Know your travel dates and track your time outside the country precisely. Keep a personal log of every departure and return. If you are approaching the 5-month mark on any trip, consider that a yellow flag moment. At 6 months, you are entering elevated scrutiny territory. Step 3. If you are planning any extended international travel, 6 months or more, consult with an immigration attorney immediately about filing Form I-131 for a reentry permit. Given the 14 to 17-month processing times, the sooner you file, the better your protection. Step 4. If you hold a green card issued after 2021 and you are from or traveling through any of the 39 countries listed under Presidential Proclamation 10998, speak with an attorney before your next trip about what documentation you should carry and what questions you may face at the border. Preparation is not paranoia, it is protection. Step 5. Stay informed. Immigration policy in 2026 is not static, it is changing, sometimes weekly. Subscribe to verified, policy-grounded sources. Follow official USCIS announcements. Do not rely on social media rumors or secondhand advice. The cost of acting on misinformation can be the loss of your permanent residency. Now let me give you some broader context about where all of this is coming from and where it may be heading. The heightened scrutiny environment for green card holders in 2026 is not the result of a single law passed by Congress. It is the cumulative product of executive action, internal agency guidance, and operational shifts within DHS and CBP. This distinction matters because it means these policies can evolve relatively quickly in either direction. They can be challenged in federal court, they can be modified by new executive orders, they can be clarified through regulatory guidance. However, there is also a realistic possibility that this environment becomes more restrictive before it becomes less restrictive. The current administration has demonstrated a clear policy priority of intensifying scrutiny at all levels of the immigration system, not just for undocumented individuals, but increasingly for legal immigrants as well. There are ongoing legal challenges to several aspects of the current travel restrictions framework. Some of those challenges may succeed and result in court injunctions that temporarily block or modify certain enforcement practices. But court timelines are long, and outcomes are never guaranteed. You cannot plan your immigration strategy around the hope of a favorable court ruling that may or may not arrive in time. What you can do, and what I encourage every green card holder watching this video to do, is operate with full awareness of the current environment. Prepare your documentation as if the rules are exactly what they are today, and consult qualified legal professionals who understand the specific risks that apply to your individual case. There is also one detail most people are missing when they discuss the 2026 green card travel environment. The risk is not just about abandonment, the risk is about a confluence of factors: your country of origin, your travel patterns, your documentation, and the internal review framework, all intersecting in ways that no single rule captures entirely. That is why a blanket, "I was gone less than a year, so I am fine" attitude is genuinely dangerous this year. I want to take a moment before we close to remind you of what is actually at stake here, because sometimes when we talk about policies and proclamations and processing times, we can lose sight of the human reality underneath all of it. Your green card represents years of waiting, years of documentation, legal fees, government interviews, stress, planning, and in many cases, it represents the foundation of everything your family is building in the United States. Your children's education, your career, your home, your path to U.S. citizenship someday. All of it rests on the continued validity and strength of your permanent residency. That is not something to take chances with. That is not something to navigate without the right information. And it is certainly not something that the rapidly shifting immigration landscape of 2026 can afford you to ignore. Permanent residency is not permanent by default. It is permanent because you maintain it, through your ties to this country, through your compliance with the law, and through your awareness of the obligations and risks that come with it. In 2026, that awareness has never been more important. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. If you are a green card holder, drop your visa category and your situation in the comments below. Tell me how long you are planning to travel, or if you have already been abroad for a while. I read every comment, and my team and I will do our best to respond to as many as we can. And if you know someone, a friend, a family member, a coworker, who holds a green card and is planning international travel in 2026, please share this video with them today. The information in this video could genuinely protect their status. That is not an overstatement. Like this video, if it gave you value, it helps this content reach the people who need it most. And I will see you in the next update.